two files, 2413525 and 2513702. Set for a probation violation hearing and pretrial conference. Is there an offer that the people are making, Ms. Robinson?
I'm sorry, Your Honor, I couldn't hear. Did you say is there an offer on these?
Yeah.
Okay, I'm sorry. Yes, the offer is the same that it was previously, Your Honor, that if the defendant would plead to the probation violation with a 12-month cap, we would dismiss the charges in the new charges in 25-13702. And that is still the offer that is on the table today.
All right. And Mr. Emlander, is that your understanding of the offer in this case?
Yes, it is my understanding of the judge.
Did you discuss that with Mr. Watkins?
I have.
And what does Mr. Watkins want to do?
He wished to take advantage of that offer. We'd only ask that with respect to the probation violation charges of the assaultive crimes, that it'd be a no contest on those.
Any issue with that, Ms. Robinson?
No, Your Honor.
All right. Is that what you want to do, Mr. Watkins?
Yes, sir.
All right. Raise your right hand, please. You solemnly swear or you affirm that the testimony you're about to give is the truth, the whole truth, and nothing but the truth, so help you God. All right, so the allegations here are that you're placed on probation in this court for a 2-year felony offense of fleeing and looting a police officer in the 4th degree. Do you understand that?
Yes, sir.
You're alleged to have violated your probation in a non-technical manner. Count 5 alleges that you violated condition number 1, that you not violate any criminal law of any unit of government. And the allegation is that on or about November 30, 2025, that you violated Michigan state law when you assaulted Jessica Frost. Do you understand the allegations contained in count 1?
Yes, sir.
I'm sorry, that's count 5. Count 6 says you violated condition number 1, same date, and that was an assault on Layla Leha. You understand the allegations contained in count 6?
Yes.
And count 7, you violated condition number 1. On or about November 30th, 2025, you violated Michigan state law when you interfered with electronic communication. You understand the allegations contained in count 7. Sentencing agreement in this case that if your no contest plea is accepted, that you would be looking at up to 1 year jail sentence with credit for 90 days. Do you understand that?
Yes, sir.
You understand that this 1 year would be in excess of your advisory guidelines. Your advisory guidelines were 0 to 11 months. Do you understand that? I understand that the probation department recommended 16 months minimum to 2 years, but the prosecution has given you a cap of 1 year in the county jail. Do you understand that?
Yes.
And that your probation would be, I guess there's no agreement, it's either be continued or revoked, I guess kind of depending on the amount of jail time that you get offended. Understand that?
Yes.
Is that right, Mr. Emily?
It's my understanding it'd be continued to March of 27, correct? Probation?
Yes, Your Honor, that was my understanding. Unless you want. Yes, that was my understanding, Your Honor.
Okay. All right. Is that your complete understanding of the agreement in this case, Mr. Watkins?
Yes, yes, sir.
Have you had sufficient time to consult with Mr. Emlander about these allegations, right to contest them at a hearing and this plea agreement?
Yes, I have.
And subject to the agreement, how do you wish to plead?
No contest.
Reason for no contest plea, Mr. Emelander?
Civil liability, Your Honor.
All right. For this finding, that's a sufficient reason for offering a no contest plea. Mr. Watkins, do you understand with a no contest plea, you're not admitting these allegations, but you're no longer denying them?
Yes, Judge.
The court will be provided with some information, and if I find that there's a sufficient factual basis for these 3 violations, that I would find you guilty of those violations. Do you understand that?
Yes, Judge.
And that you'd be sentenced on this probation violation up to a year in the county jail. Do you understand that?
Yes, sir.
You understand that if your no contest plea is accepted, that you're giving up the right to contest these allegations at a hearing. You understand that you'd be giving up certain rights that you would have at that hearing.
Yes, Judge.
You were previously advised of your probation violation rights at the time that you were arraigned. You remember reading that document?
Yes, Judge.
Did you understand those rights?
Yes.
And you signed a document back then, is that correct?
Yes, sir.
Have you been over those rights again with Mr. Emelander since then?
Yes, sir.
You also understand that you might be giving up the right to appeal any appeal issues you may have if you had a contested hearing and I found you guilty.
Yes,
Speak
sir.
up. You understand that you are giving up the right to appeal this conviction and sentence. If you wish to file an appeal, it'd be by application for you to appeal in the Court of Appeals, and it's not an appeal by right.
Yes, Judge.
You now give up the right to contest these allegations at a hearing and all the rights that you would have at that hearing, and you affirm your no contest.
Yes, Judge.
And Mr. Emelander and Ms. Robinson, there is, I guess, somewhat of a agent descriptions of the offense. There may be more in the police report, but it's included in the PSI. Any objections? The court would use that to see if there was a sufficient factual basis.
No, Your Honor.
No, Your Honor.
All right, the court has had an opportunity to review the report. I do find that the elements of these 3 violations are contained therein. Are the attorneys aware of any promises, threats, or inducements which have not been stated on the record?
No, Your Honor.
No, Your Honor.
Is Mr. Watkins competent to enter this plea?
As far as the people are aware, Your Honor.
Yes, Your Honor.
As the court compiled the court for taking a plea in a probation violation case?
Court has, Your Honor.
Yes, Your Honor.
right, the court does find the plea to be knowing, understanding, voluntary, and accurate. All right, there's been an updated report. Do the parties wish to proceed to sentencing today?
Yes, Your Honor.
Yes, Your Honor.
And Mr. Prosecution Defense, was the report timely made available to you?
It was, Your Honor.
Yes, Your Honor.
All right. And all right, the court did receive the sentencing memorandum from you, Mr. Emelander. Did you have an opportunity to read the report and discuss it with Mr. Watkins?
Yes, Your Honor.
Do you have any additions, corrections, or changes?
Not to the report, Your Honor.
Anything that you'd like to say on this behalf?
Yeah, so as the court's aware, we did file a sentencing memorandum with the court. Here today, supported by his family. Jessica Frost, the victim in this case, is also here. At some point, if the court is willing, she'd like to address it in court. But his employer with Upper Echelon Services is here today. He drove 4 hours from Bowling Green, Ohio to be here to support him today. We attached a letter to the sentencing memorandum outlining the type of person that Bill Watkins is to the company and who he is as a person. And that's Christopher Lindquist that's here today. Also, since the incident took place back in November of last year, he's undergone significant utilization of resources available to him. He completed a period of time as an inpatient at Pine Rest. We attached documentation showing that completion of the program. He completed everything to the T in there. Dr. Cameron Reisma authored that correspondence where he was admitted on December 19th and stayed there until he was discharged on January 2nd. Insurance covered a portion of that, but he covered the majority of the out-of-pocket expenses. He's incurred significant expenses to utilize these resources. We set that forth in the sentencing memorandum as well. Immediately after his discharge from completing the inpatient detox and residential treatment program, he started an intensive outpatient program through Pine Rest, where he has been attending 3 days a week since January 6th. It's my understanding that he completed that last week. We attached a letter from the therapist setting forth his participation and explanation to the court what he does during those sessions. He's also completed 10 sessions through Allison. We attached those certificates, self-help program. Each program is about 2 to 4 hours in duration. He has to take a test and complete each test with an 80% passage rate. And that was all at his own expense as well. And those certificates kind of address what the underlying issue that Mr. Watkins struggles with, alcohol primarily, and some anger issues. It's my understanding through probation, he started the domestic counseling program through there. It's a 52-week program on Mondays, and he's completed a couple sessions of those. He was on probation at the time of this offense. He messed up. I think he's realized that alcohol is a problem in his life, and that causes him to act the way he does when he's drinking. He hasn't drank since the incident happened. He's on a GPS tether and also an alcohol monitoring device. Sometimes it takes people multiple times to screw up before they realize their mistake. And I think this time he's seen the actions, what drinking does to him. And I think he's finally come to reality of what his issues are, and he needs to address those issues, which he has addressed them. And he's gonna have to address those issues the rest of his life, dealing with alcohol, and staying away from alcohol, and maintaining sobriety, and addressing the anger issues that flow from the substance issue that he struggles with. He's a completely different guy today. Since coming into my office after this happened, I can see the change in him. He's a calm guy, calm, collected. We're asking the court to, is inclined to put any sort of incarceration that it be on the weekend so he can maintain his job. He'll be on the alcohol monitoring device in case he, drinks. That'll automatically tell probation that there is an issue. I haven't seen anybody do as much utilization of resources that Mr. Watkins has done. He's done basically everything under the sun that he can do to figure out his issues that he struggles with in his life. We'd asked the court to allow him to have contact with his fiancée. She's here today. He has children with her. If the court is inclined to hear from her, we can have her speak. Then Mr. Watkins would also like to address the court.
All right, Mr. Watkins, have you had the opportunity to read the report and discuss it with Mr. Emlander?
Yes, sir.
Do you have any additions, corrections, or challenges?
No, sir.
Anything that you want to say on your own behalf?
Yes, sir.
I've made a lot of mistakes in my life and in the past. And as of this most recently, I mean, I could lose everything that I've worked my whole life for, 16 years or more. And I've been living my life on pride and ego, thinking that I didn't have a problem drinking, because I didn't think that at the time. So I've taken steps to try to understand and see it. I do have a problem. I did have a problem. And almost 90 days now is the longest I've been sober in my life, traveling, construction, and everything else. I'm healthier than I've been in 15 years. I feel good. I want to apologize to my family, my coworkers, and everybody in my life, because I didn't think that my drinking was affecting me. And I thought it was just me. And I understand that my obvious choices and lack of judgment in that quick of a moment, I'm going to lose everything. And I had to make a change, and I feel better. I've done all this therapy. I've continued, and I plan on continuing. I learned to be a different person because I'm not drinking anymore. And, I know that in my PSI as well, my probation said that, I was a potential danger to the public, and that's kind of hurts my feelings some too as well, because I know if they knew me or anyone outside of this scenario or case in court, I'm not that person. I'm not that person. I've had some shortcomings. Not addressing to the best of my ability at this point. Thank you.
I'm a little bit confused, Mr. Watkins. You've indicated that you're not that type of person. In reading the description of this violation, that you put your hands around the throat of apparently your fiancée and choked her out. What kind of person does that?
Not a person in a good place and drinking like I was, Judge. I've had to live with every day that I put my hands on her and I lost my cool in a moment, and I just wanted her out in that time. I thought that that was the right decision. And in that moment, that wasn't ever the right thing to do. Drinking, and I just wasn't thinking either in that time. I wanted her out, Judge. We were arguing.
Okay, so why'd you punch Layla in the stomach?
That never happened, Your Honor.
It's in the report.
That's what they say it is, but that never happened. I grabbed her and I moved her directly from my living room 10 feet to the door and out the door. My daughter had hit me at the time and I knew she was there. I did not stop in any time. Motion never hit my child. I have 7 children that I'm involved with every single day and raise, and even my other 3 that I don't get to see, that I still see them every weekend. But again, I'm not a violent person towards my kids. I'm not.
So Layla lied to the police?
I believe it was a lie. She's had issues with that in the past. She's 9. Not with issues in this situation, but lying, and I think she was scared. I don't know, but I know that I never turned and I didn't put hands on my child.
The report says that she pushed you, trying to get you off of her mother, then you turned and punched her in the stomach, and she told the police that she had stomach pain after being punched by you.
I know that I did not turn and hit my child. I think that she was scared. I did not hit my child, Judge. I know that for a fact. She didn't push me. I was pulling her out the door. I had the door open, and she was hitting me on the side of my head and face, which I got that lip from it, but I did not ever stop at any point to hit my child. The investigation as well. She did that. She was lying through an investigator because she wanted me to be in trouble for her and her mother fighting. She felt that I needed to be in trouble for her.
So was Jessica lying when you said that you choked her out?
I don't think I choked her out, Judge. I did grab her, but I even told the officers as well. I did grab her by the neck and her coat that she had on and drug her out. I didn't choke her. Choking her, I don't know. But I did grab her by her neck and her jacket, the side of her arm, and yanked her and drug her out to the door.
The report says that you put 2 hands around her neck and choked her for about a minute.
I don't believe that to be true, Judge. I was drinking, like I said, but I just grabbed hold and pulled out, moved her out. I mean, I obviously maybe choked her while that was occurring, but I didn't choke her.
You dragged her out of her house like somebody would drag a dog out of the house. They need to go outside, right?
I don't think that sounds like a lovely way. Yes, sir. Just pulled her outside.
Dragged her out like a dog. No? Okay. All right. Ms. Robinson, any additions, corrections, or challenges?
No, Your Honor.
Anything that you want the court to consider?
Your Honor, I'd like the court to consider that the 12-month cap was offered by our office. The recommendation from the agent was prison. People are sticking with that offer because of the statements we have had from the victim since. So I would ask the court to sentence pursuant to the offer that we made. However, I would ask the court to maximize the amount of time that he gets here so that when he's out, if he violates again, Prison is all that is left. I think it is important to note that the minimization here leads me to believe that all of the work that is being done is simply for the purpose of looking good to the court and trying to avoid jail time. It doesn't actually seem to be anything genuine by the defendant. He just, every question, minimized what happened. You know, he said he just took her outside. Ms. Frost indicated to the officer that when he dragged her outside, he body slammed her so hard onto the porch that she urinated herself. The fact that his daughter, who he claims was punching him, but he put no hands on, felt the need to intervene as he was attacking her mother. I find that to be problematic. We have heard from the victim. She has indicated that she wants all of this dropped. She doesn't remember it and makes a point of telling our office that she can't afford to live without the defendant, that he pays the bills. I believe that this is a family that is in a situation where the fact that he is the provider is leaving them in a state of needing to be controlled, even in the last, 2 minutes where you questioned him. I know you heard this, but you asked him what kind of person chokes someone out. He said, oh, someone not in a good place who's drinking. And then later when you said you choked her, that's what it said. He said, why? I don't really think that happened. So I would ask the court to sentence pursuant to the offer that was made. We will dismiss the new charges as we said we would, but I would ask the court to consider all of that when deciding how much of this time he should serve and before making any decisions about the no contact order. Thank you, Your Honor.
One question for your,
Yes, Your Honor.
both of you. The 2024 domestic and district court here on the PSI, it shows it was pending with a sentencing date of March. Did he end up pleading to that? Was he sentenced on the domestic district court?
I don't recall he's putting on probation. 6 months. Yeah, he thinks he may have been on probation on that one.
I did 6 months of probation for district.
6 months of probation
Okay.
in the district.
And was the victim in that case Ms. Frost as well?
I believe she was. She's here today.
Your Honor,
Yes.
my notes indicate that there was a deferred sentence on the misdemeanor domestic violence in the district court here.
Okay. They successfully completed the deferral?
It appears so because he was discharged from probation successfully on September 26th of 2025, Your Honor.
All right, the PSI says he's got 90 days credit, where he did 2 days on this file, originally 2 days, then sentenced to serve 87 days with 87 days credit, and he served 3 days for posting bond on this probation violation. Does that sound right, Mr. Watkins? You served 87 days in jail?
Yes, sir.
Judgment sentence says you served 45 days. You had 11 days credit, and you served 45 days. Over 45 days, 11 credit, you had 34 to serve.
Are you talking about the underlying charge, Judge?
Yeah.
Yeah, I think that, all right, so what had happened in that case, from what I recall, is that he bonded out, but probation thought he was still in jail while he bonded out, so that they had it 90 days
Okay.
of him
So
serving where
so you
he,
served 45.
I think that's the number, Judge.
Okay. Okay. That's what we had as a credit for 48. All right, the court recognizes that the advisory guidelines in this case would suggest a sentence between 0 and 11 months. The courts can exercise my discretion, sentence consistent with the advisory guidelines, consistent with the agreement in this case. It would be the sentence of the court that this defendant served seven months in the Nuevo County Jail. I'll give him credit for the 48 days that he's served so far. Is going to be continued on probation with the same terms and conditions as was originally imposed. Mr. Watkins, the court probably would have given you the 11 months or a year, but you have been, say, I'll use the term generously, you've been working on some issues. I don't know if you've just been going through the motions or if you've been actually working on the issues, but at least you're trying. You got a long ways to go. You can tell from my court's questioning and dissatisfaction with your answers, you still haven't internalized what you did, I don't think. But you spent a fair amount of money, you've been trying to do the right thing, so that's the only reason that you're getting 7 months and not the year. You do have the right to make application for leave to appeal your conviction sentence. If you cannot afford an attorney, the court appoint an attorney to represent you on the appeal request for a lawyer must file the court within 42 days. You need to get it.
Judge, just for clarity, is it no contact lifted with Jessica Frost? Because I think that was lifted with the original probation violation.
No contact. You choked her. No contact.
This case wasn't just about a probation violation, it became a live courtroom dissection of accountability, denial, and power. What started as a negotiated plea quickly shifted into a credibility battle between Mr. Watkins and the court. The turning point came when the judge directly confronted him about the allegations of choking and assault. Instead of full ownership, Watkins minimized. He admitted to grabbing, dragging, and being intoxicated, but resisted the word choked. That hesitation changed the tone of the room. The prosecution capitalized on that minimization, arguing that real rehabilitation requires full acknowledgement, not selective memory. The most powerful moment came when the judge compared the act of dragging the victim to dragging a dog, a sharp metaphor meant to strip away euphemisms and force clarity. It was blunt, uncomfortable, and intentional. Despite visible efforts at sobriety and treatment, the judge made it clear progress does not erase violence. 7 months in jail, not the full year, was framed as conditional mercy. The court recognized effort, but questioned sincerity. Most significantly, the no-contact order remained in place. That decision underscored the court's primary concern, protection over reconciliation. In the end, this hearing illustrated a hard truth often seen in domestic violence cases. Remorse competes with minimization, and the court must decide which one it believes. The sentence reflected a balance between punishment and opportunity. But the message was unmistakable. Rehabilitation requires more than programs and payments. It requires ownership. The final gavel didn't just close a case, it exposed the thin line between regret and responsibility.